So the legal process developed in such a way as everyone affirmed the priority of the Reconstruction Amendments and the Reconstruction Amendments promises, particularly those promises concerned with fundamental citizenship, the right to vote, primary among them, and early, and first, if in effect, recognized. Secondarily, despite the primary concern to assure the rights of slaves, it was understood at the time and affirmed that that same language also embraced citizens to be on what were then reservations in the United States. The reservation policy had been developed subsequent to 1824. It represents, of course, one of the sorry periods in United States history, and spawned numerous abuses. And it's proper to conceive that we only begin to cure those abuses when we passed the Reconstruction Amendments at the end of the Civil War. The first promise that there was a future in the United States for persons Indian in the United States was made in that context, not in treaties, not in congressional legislation, but in the Constitution itself. That fact establishes an irreducible minimum of concern for the rights of Indians in the United States. So we begin this particular conversation recognizing that irreducible minimum. Now, concerning that, it's important to make an observation. When we in the United States say something is constitutional or something is unconstitutional, we have a choice to make about how we mean that, how we interpret those expressions. We could, for example, mean the Supreme Court has said it's constitutional. Or we could mean that it is the heart and soul of the Constitution that is at stake in the judgment that we pronounce. We are not always in harmony with the pronouncements of the Supreme Court. But it is absolutely vital to recognize that those pronouncements are law. What the court declares to be constitutional has to govern us in our legal reasoning. It does not govern our constitutional reasoning. There is no better model for us to follow in this regard than the model of Abraham Lincoln responding to the landmark Dred Scott decision, 1856-57. That is, of course, the notorious decision in which the court ruled that black people could not be citizens in the United States, never were intended to be citizens in the United States by the founding fathers, and could never qualify for citizenship in the United States by reason of natural differences. It was an extraordinary opinion, to say the least. Abraham Lincoln responded to that opinion in two ways. First, he produced an extraordinary historical account demonstrating the factual errors in the deciding opinion in that case. Secondly, however, and for us most importantly, Abraham Lincoln also affirmed that while the opinion was wrong in substance and morally wrong, it nevertheless had to govern us in our legal relations until such time as it were altered. And it is that balanced approach that Lincoln took which constitutes for us the pathway to addressing our concerns with the Indian Child Welfare Act. In its original legislative conception, some of us will argue, it was legislatively in error, even when well-intentioned. In its constitutional foundations, it rests on claims of authority on the part of Congress, which are incongruous with our constitutional tradition. Nevertheless, it became law. And as it has been more than once upheld as law, and constitutional by the Supreme Court of the United States. It governs our legal relations in that respect.